Hi, good day. So this is a simplified civil procedure flowchart. So if you want to see a more detailed explanation, you can subscribe or join to my subscribers so that I will share there the more detailed explanation. So this is according to the 2019 amendments to the 1997 rules of procedures. So let's start. It all begins with what? No, so civil case, it all begins with this uh, primary event, and that is the cause of action. So let's make it red. Cause of action. Sorry. All right. So first, the cause of action. It means what's that again? It means act or omission whereby the defendant allegedly violated the right of the complainant. So that's the definition of a cause of action. Okay. All right. Let's make the color of the text white. Next is we have. So after that, there's filing of the complaint by the complainant. So let's make it a little bigger. Okay. So after the filing of the complaint, or what are the requisites? Okay. So the requisites must comply with Rule 7, okay, of the 2019 amendments, and also if required, if applicable, certificate to file action from the Katarungang Pambarangay. Now that means barangay conciliation certification that the amicable settlement has been done within the barangay. So again, just to review, if the residents are within the same barangay or within the same city, even though different barangays, as the case may be. Okay, there are exceptions as well. Payment of docket fees as well, but the other option is motion to sue as indigent. So filing of the complaint, then we have to pay the docket fees. Okay, let's make it a different color. So the other option here is to uh, sue as an indigent. Okay, motion to sue as an indigent. So there's an option here. Okay, so after that, we now proceed to determining the venue as well. So, of course, payment of docket fees and determination of the venue. And of course, for civil procedure, for civil cases, what we have to remember is that uh, for claims, no, according to the latest amendments, for civil actions, for civil cases, you file it with the RTC if the claim is incapable of pecuniary estimation. And of course, for the venue where the residence, no, of the party is. And also if the claim, other cases, if the money claims, if the value of the money claims exceeds what, 2 million pesos, that's with a RTC. Also, if it involves real property, title to or possession of real property, if it exceeds 400,000 pesos. And if matters of probate if it exceeds 2 million pesos. Also file with the RTC of the residence of the complainant if it involves contract of marriage and marital relations and juvenile and domestic relations. Okay, file with the MTC if it does not exceed 2 million pesos in claims, okay, money claims, or if it involves personal property where the value of the property does not exceed 2 million, as well as claim of money does not exceed 2 million. But if it involves title to or possession of real property, the value of or amount of the assessed value must not exceed 400,000 pesos. Also, with forcible entry and unlawful detainer cases, file with the MTC. So that's with a consideration of the venue. Okay. So after that, after payment and determination of the venue, you file with the court. What will the court do? They will examine. Okay? They will examine the allegations. And with that, the court will determine if it has jurisdiction, of course. No? So, can the court still dismiss? Yes, under Rule 9, there are 3 grounds for the dismissal by the court. Okay? So if there are no grounds, if the grounds under Rule 9 are not present, then the court will proceed with what? With the issuance of what? Summons. Okay? Which I will explain in another video. So if there are no grounds of dismissal under Rule 9, the court will issue summons, and that will, as a recall, that will cause, no, the acquisition of the court of jurisdiction over the person of the respondent. Okay, so after the issuance of summons, uh, technically the respondent will now file what? So if you receive a summon, you will now file an answer. Okay. But sometimes you are not so it's not so clear, it's not so definite what is the allegation, what are the allegations of the complainant. So ano yung ifa-file ng defendant? He will file what? A motion for bill of particulars. Okay? So this is the other direction. Okay, file a motion for bill of particulars, and if the court will grant it, then the adverse party must comply within 10 days. So for the summons, by the way, this is issued by the court 5 days from the receipt, no, of the complaint. Okay, and when the defendant received the summons, he has 30 days. He has 30 days to file an answer. So we have your respondent has 30 days. So once he has filed an answer, the respondent can now also include, no, or attach sa kanyang answer what? A counter claim. Okay? A counter claim. And a counter claim is one where a person has a cause of action then as to the others. Okay? As to the petitioner or the complainant. Okay? And just to recall, if the counterclaim or if the answer has attached with a counterclaim, and the counterclaim has attached an actionable document, what should the petitioner do? He must file a what? A reply. Okay, without the reply, denying the genuineness and the due execution of the actionable document, then generally the court will deem it executed, no, genuine and duly executed. So if the defendant will fail to file an answer within the time period, which is 30 days, then the court can now what? Can now, um, upon the motion of the claimant, notice to the adverse party, the court can now declare the the defending party in default, no? Plus also proof of such failure. So ito, if this is if hindi siya na-answer within the time period, kailangan pa rin ng motion uh, from the complainant or the claiming party, again plus notice to the defendant and proof of such failure. That's when the court can declare the defendant in default. But kung nakafile naman siya ng answer on time, then the court will now proceed with the determination kung they would resort to judgment on the pleadings or summary judgment, because this is possible. So, judgment on the pleadings pag ang answer fails to raise, no, an issue, or there is an admission of material allegations. So, yan yung resort. And if it's no genuine issue raised, then summary judgment. So again, nagbabase ito sa answer. Okay? Pag ang answer again fails to tender an issue, or there's admission of the material allegations, then judgment on the pleadings. However, if the defendant fails to raise a genuine issue, or the issues raised are sham, fictitious, or not genuine as shown by the affidavits, depositions, or admissions, then the court will proceed with summary judgment. Okay? Kung hindi naman ito i-grant ng court, yung either of these two, okay, the court may now proceed, no, with notice of pre-trial. Okay? Pag may genuine issue, in other words, pag may issue na raised and may genuine issue, then there is or there should be pre-trial. Okay? And of course, that starts with notice of pre-trial. So what does notice of pre-trial contain? Okay? It would contain the what? First, the pre-trial itself. Okay. Number 2, court. So it will contain the dates. Okay, the date of pre-trial, the date of court annexed mediation, and the date of judicial dispute resolution, if necessary. Kasi if the judge still believes that conciliation is still possible, then JDR, resort to JDR. Okay? And also, this will be the application, where the application of the various modes of discovery. Okay? So after notice of pre-trial, again, ano yung ginagawa sa pre-trial? Yung main things na ginagawa dyan is yung admission of facts, no? Kasi isi-simplify, no? Ibo-boil down kung ano talaga yung issue para sa trial proper, hindi na maaksaya yung oras. So we stick, no, So, dyan din natin i-condense kung ano yung issues to be resolved, ano yung evidence na i-present, at sino yung mga testimonies. So, sa notice of pre-trial, so bibigay yan ng court, no? After that, yung parties magsasubmit ng pre-trial brief. Okay, pre-trial brief. Ano naman tong pre-trial brief? Ito yung isasubmit ng parties that will contain the statement of the case at yung prayers nila. And then, admitted facts and proposed stipulation of facts. Okay, the factual and legal issues to be tried or resolved. No? Kasi, pag kunwari dininay dito, syempre dito malalaman sa answer. So, pag dininay, pag may specific denial, then there is an issue. Okay? So, sa pre-trial dyan, ipropose ng party. The documents na ipapresent, na imamark for presentation, the names of the witness, of course, if there is object evidence and documentary evidence. Okay, the propriety of referral of factual issues to commissioners, a brief statements of points of law and citation of authorities. So, just to prevent surprises during trial. So, after pre-trial brief, kumbaga ito yung mga propositions, ito yung mga summaries. We now go to pre-trial conference. Okay, lakihan natin kasi ito yung kumbaga main event. So sa pre-trial conference, again, dito na yung magkabila ang party, no? Ang gagawin is babasahin, for example, ng prosecution, hindi civil case. So babasahin ng complainant yung kanilang pleading. Okay? So naka-paragraph numbers 'yan. So pag they will read number 1, then may kopya si defendant, the defendant will say admitted, denied, admitted, denied. So, dito malalaman kung ano yung inadmit na facts ng defendant, okay, at ano yung kanyang dinideny na facts. Kasi yan yung issue na i-resolve by the presentation of evidence during the trial. So, kunwari na-deny na, no? Na-accept, na-deny yung facts, na turo na yung presentation of evidence, o ganito, i-present namin yung birth certificate, yung marriage certificate. Now, the court will go to the issuance of the pre-trial order. So, sa pre-trial order, it will include the enumeration of the admitted facts. So, i-condense, i-merge, kumbaga, kung ano yung napagkasunduan. The minutes of the pre-trial conference, the issues to be resolved, both legal and factual, the applicable laws, evidence mark, okay, at yung flowchart, no? Yung dates ng mga trial. So after the pre-trial order issued by the court, may chance pa ritong makonsider yung judgment on the pleadings uli at summary judgment. Kung walang issues at walang genuine issues raised. Okay, pag hindi naman applicable, dito na tayo pa rin sa court annex mediation. CAM, no? Mediation or compromise agreement. Kung hindi pa rin successful, okay, pag hindi successful, so pag successful, approval of the court, no? Isa-submit yung compromise agreement. Pero pag hindi successful, magpo-proceed lang sa judicial dispute resolution if the judge still believes that resolution is still possible. Okay? Pero pag hindi na, proceed na tayo sa trial. Okay? Pero syempre, sa judicial dispute resolution, pag may submission of compromise agreement, then i-approve na lang ng court, wala ng trial. Okay? But if wala pa rin, hindi possible yung judicial dispute resolution, we go to the trial proper. And how does a trial start? It starts with the presentation of what? Presentation of evidence of whom? of the plaintiff. Siyempre, walang reverse trial kasi sa criminal procedure yon, in cases of self-defense, no? So, presentation of evidence of the plaintiff, siya yung mauuna usually. At ito ay set not later than 30 calendar days after the ruling on the plaintiff's it's 30 calendar days after the termination of the pre-trial conference. So, itong presentation of evidence within 30 days, no? After the termination ng pre-trial conference. And then, yung plaintiff shall be allowed to present its evidence within what? Within a period of 3 months. Okay? So, within 3 months. So, after the presentation, posible pa dito mag-file yung defendant ng what? Demurrer to evidence. Meaning ng demurrer to evidence na the evidence failed to establish, no? Failed to establish the case. And therefore, the case should be dismissed. So, if granted by the court, i-dismiss na yung kaso. Okay? Pero pag hindi naman nag-file ng demurrer evidence at it meets the burden naman of proof, then the court will now proceed with the presentation naman ng defendant, with the evidence of the defendant. And this is done within what? This is done within 30 days after the court's ruling on plaintiff's formal offer of evidence. So again, after na nakapresent ng evidence yung plaintiff, i-offer niya na ito, no? Yung documentary and object evidence, verbally niya offer, no? At the when it is about to rest its case, no? And yung syempre yung testimonial evidence is being offered at the time the witness is called, no, to the witness stand. So after that, after na ma-offer yung evidence, within 30 days, dapat makapresent na rin ng evidence yung defendant. And the defendant has also 3 months or 90 days to present his evidence, okay, to support his defense. And then, also, it is allowed to have third-party presentation of evidence or third-party claims after mag-present yung si defendant. So again, third-party claims are claims to parties that are not members of the original complaint. So that's the third party complaint. No? So after that is nakapresent na, ano nang gagawin? Pwedeng mag-rebut, no, ang isang party sa evidence. Okay, rebuttal of evidence shall be completed within a period of 30 days, 30 calendar days for each. So tandaan yung word na calendar, ha. Calendar days, 90 calendar days, 90 calendar days, and posibleng may rebuttal of evidence, rebuttal evidence. So pwede dito, no? This can be done. After this is the judgment na. So the judgment must be made personally by the judge. Okay, citing the applicable laws and the facts distinctly, clearly, and it must be signed by him personally. So hindi lang written and prepared by the judge personally, it must also be signed by him and filed with the clerk of court. So that's the judgment. Usually, we now go here to the promulgation of judgment. After the promulgation of judgment, we can now go to execution of judgment. So iba yun, execution of judgment sa judgment. Execution of judgment is done by the winning party or prevailing party. And this is a matter of right, and he can file for it within 5 years from the entry of judgment. So actually, this is called entry of judgment. So 5 years. Within 5 years, ipapa-execute mo ang iyong napanalunan. So, ano yung order man ng court, it's the job of the sheriff or the police or whatever agency or board of the government. Ang gagawin niya, ang order ng court. Okay? Because it's the highest, no? The highest authority in the judiciary branch of the government. So this is the simplified civil procedure chart once again. Okay, so just to recall, I'll just show it up.